All right. Hello, East Africa. Good afternoon, ladies and gentlemen. You're all most welcome for this very special session. And if you're joining in, please feel at home. My name is Gabriel Achai, and I'm speaking to you right here at the East Africa Law Society House in Arusha, Tanzania. We are profoundly honored to host you today and look forward to having a very fantastic discussion on abductions, enforced disappearances, and extrajudicial killings. And in particular, today we'll be exploring the emerging rule of law challenges and opportunities in East Africa. Now, I do not want to preempt the discussions, but like you know, East Africa has become quite notorious for this subject matter lately. And today we have a distinguished panel of experts that is being moderated by Mwalimu Evans Ogada, who is our chairperson of the East Africa Rule of Law Committee. Mwalimu, we are all yours. We are streaming the session live on YouTube and on Facebook. So we have a wider audience than those that are catching us right here on Zoom. And you now have the opportunity to take us away for the next 2 hours. Thank you.
Thank you very much, Gabriel. Thank you, my brother Gabriel from Arusha. Ladies and gentlemen, good morning, good afternoon, good evening from wherever you're watching, and welcome to today's webinar, Abductions, Enforced Disappearances, and Extrajudicial Killings, Exploring Emerging Rule of Law Challenges and Opportunities in East Africa. Thank you for joining us as we delve into a critical issue that has profound implications for security, human rights, and regional stability in East Africa. Abductions, whether driven by conflict, criminal activity, or political motives, have become a growing concern in the region. They not only threaten the safety and well-being of individuals, but also undermine trust in institutions, and they not only threaten, the safety and well-being of individuals, but also undermine trust in institutions and disrupt communities. Today, we aim to shed light on the root causes, patterns, and consequences of these abductions, as well as exploring potential solutions and collaborative efforts to address these pressing challenges. We are privileged today to have a stellar cast, a panel of distinguished experts, and I will introduce them shortly. They will share their insights and experiences. Their expertise will help us better understand this issue and identify actionable steps towards prevention, response, and recovery. We will have a conversation amongst friends, and we would need to start with the panelists giving us their broad ideas. Then we'll have a brief Q&A session. Then after that, we will see if time is left. We may take comments from the audience. I want to acknowledge the courage of those who have been affected by abductions, particularly those in Kenya, as well as the tireless efforts of organizations and individuals who are working to combat this issue. It is through collective awareness and action that we can hope to create a safer and more future for all. With that, let us begin. I introduce today's panel. We are joined by Professor Thomas Mile. Professor Mile, he comes to us from Kenyatta University, where he teaches law. We have Dr. Sarah Birete, Executive Director, Center for Constitutional Governance, CCG, in Uganda. We have Senior Counsel Charles Kanjama, Managing Partner, Muma and Kanjama Associates in Nairobi, Kenya. Lastly, we have my brother and my good friend, Mr. Onesmo Olengurumwa, National Coordinator, Tanzania Human Rights Defenders Coalition. Mr. Ngurumwa is doing a very good job in Tanzania. We begin. I start off with Professor Thomas Mile. Professor Mile, I want you to give us your opening remarks around the theme aligning East Africa domestic laws with international human rights norms, strengthening regional cooperation to address these pressing issues. Thank you, Professor Mile. We expect to hear from you.
Thank you very much, moderator. Good afternoon, ladies and gentlemen. Honored to speak to you. I will be sharing my presentation time with 3 Gen Z researchers with whom we did a field research on enforced disappearance in Nakuru, Kenya. They're among the attendees. I think Gen Zs in Kenya, and not only in Kenya, have really deserved to have their voices heard. So we'll start with the international framework. We have quite a number of useful treaties and documents. We have an International Convention for the Protection of All Persons Against Enforced Disappearance from 2006. It's according to the convention, the state parties must criminalize enforced disappearance. It must be made a crime to make people disappear forcibly. The states must ensure that there's criminal responsibility for those who engage in those acts, and also for their supervisors, who knew about enforced disappearance, had knowledge, but failed to take action. The convention also provides for the duty to investigate, and there's also a right, according to the convention, a right that nobody should be subjected to secret detention. And there's also Article 26 of the convention, a committee on enforced disappearance, which monitors the obligations of the state parties. Unfortunately, out of the 8 EAC partner states, 4 states have signed the convention, 4 did not even sign, but none of the states ratified the convention, so none of the states is a party as we speak today. Then we have a very useful document, a 90 pages strong document from the African Commission on Human People's Rights of 2022, guidelines against enforced disappearance. It elaborates on the context in which enforced disappearances happen and the vulnerable groups. For example, the women who are subject to secret detentions and are vulnerable to sexual abuse, and also those women and children who wait for those who have been disappeared. We have an obligation to refrain from conducting enforced disappearance, to prevent enforced disappearances, to search for people, and to investigate the cases of enforced disappearance. Then we have a definition of those documents, so the binding treaty, the convention, and the soft law, African Commission guidelines. What is the definition of an enforced disappearance? So it is briefly arrest or abduction with the consent of state agents and the refusal to acknowledge the whereabouts of the person concerned, which basically places, as a key issue, places this person outside of the protection of the law. So that's international. Let us come to the EAC, to the regional cooperation, and the instruments which we have aim at ensuring that we have regional cooperation in preventing and investigating enforced disappearances, and not regional cooperation in perpetrating enforced disappearance. Most famous case, East African Court of Justice, a very accessible court body of useful jurisprudence on the rule of law and human rights. A case from 2011, Plasheda Rugumba. There was a Rwandan army officer, the wife who was arrested, who disappeared. The wife was making inquiries. The wife was harassed for making inquiries. The elder sister of the officer filed a reference with the East African Court of Justice. She filed this reference in November 2010, after 5 months, a couple of months of waiting for her brother to find out what happened to her brother. In January 2011, just 2 months later, the brother, the officer, was produced in the Rwandan military court, and the arrest was regularized. But the family could find out about his whereabouts. We see that the regional organs, the East African Court of Justice, was helpful to establish, to expose the Rwandan authorities at that time, to expose them as involved in cases of enforced disappearance. And the strategy of exposure, the mere filing of reference, not even winning the case, the mere filing of reference helped to draw international attention to the case. Now, my final remark, East African Legislative Assembly also has tools to do the same what the East African Court of Justice did. It can discuss any matter pertaining to the community. And we know rule of law is an operational, a fundamental principle of the community, also a protection of human rights, also the rights against enforced disappearance. We have a Committee on Legal Rules and Privileges, which used to conduct hearings in the aftermath of 2016 Burundi coup. Hearings were conducted in Burundi following the crackdown after the failed coup, and some of the cases of human rights violations were exposed. There is a right to petition the East African Legislative Assembly, Rule 86. And the committee and the East African Legislative Assembly can conduct research within its area of competence, and may also pass resolutions. And this is what East African Legislative Assembly, or the in a number of cases, was doing. So East African Legislative Assembly also can be active in saving and searching for people who are missing, who are subject to disappearance. And that's basically it on my part. And now I hope we can make it technically possible to cede the floor to my Gen Z researchers. The first one is Alvin Kubasu. I see him among the attendees. Thank you.
Alvin, welcome. You have about 3 minutes to address us.
Thank you so much to the moderator, and thank you, Professor Thomas, for this opportunity. As rightly introduced, my name is Alvin Kubasu, a graduate assistant at the Strathmore University Law School, and also a former student at Kenyatta University School of Law. In making this presentation, I will be doing so with the help of my fellow researchers, that is Lorraine and Charles, whom we did this research together. I'll primarily focus on the legal inadequacies that exist within the Kenyan framework, and then Lorraine will talk about the grief that families have to go through, and then Charles will talk about the effect of this demonstration to the youth and especially to the Gen Zs. Now, when we talk about enforced disappearance, we often put it in terms of statistics, numbers, and trends. However, would like today to talk about it from a point of putting faces and a human touch to it based on actual accounts that we got from the people that we interviewed when we are carrying out this research. When you talk about legal inadequacies, for instance, here, you see, it's often said that when a hyena wants to eat its children, it starts by accusing them of smelling like goats. And this is the exact instance that Nakuru residents were faced with in 2021, where the police started by making obnoxious accusations that there are gang members around and they want to end this. And they started picking people at random. Unfortunately, this was the plight that fell two brothers, that is Sam and Kelvin, not their actual names. But they were arrested at random and they were killed in cold blood. No investigations and no actual, the police being held accountable. And the rationale for this was the police wanted to send a message. Now, based on also the continuing with the interviews that we had and based on the response we got from the victims, is that we deduced two particular factors which facilitated this type of conduct by the police. First is the fact that IPOA in itself is based on its composition and its mandate. It is not at placed in a good position to watch over the conduct of the police. This is because first, the IPOA is essentially police officers investigating their fellow police officers. And they do this to the benefit of their colleagues, because when the residents identify that these are the police officers who are killing people indiscriminately, IPOA actually recommends these people to be transferred to other unknown regions. And so they move away from where the public are detested against them. And second, the fact that also IPOA in itself doesn't have prosecutory jurisdiction or mandate, and therefore they can only do enough in as far as even in instances where they decide to do that. And the second point, as I conclude, has been rightly pointed out by both the moderator and Prof, is the fact that enforced disappearance, the convention has not been ratified. And this now leaves this heinous crime of enforced disappearance to be prosecuted as an offense under murder, abduction, or both. Now, this makes it to be reduced in terms of its gravity and the effect that this presents to also to the victims, and they end up even in certain instances not getting justice. So at this point, allow me to cede the floor to Charles to address now how these enforced disappearances have affected the youth, and especially in light of the recent demonstrations that were witnessed in Kenya. Thank you, Mr. Moderator.
Thank you very much. Lauren, is Lauren Odwar?
Sorry, next is, I think, Charles Njibwakale. He's on
Charles.
the list. Charles Njibwakale. Yes, I see.
Who is
he's
Charles?
already updated.
Hello, guten Tag. Good afternoon. My name is Charles Juma, an exchange student at Humboldt University from Kusol. I also took part in this research. And as I've rightly pointed out by Professor Milej and also Alvin on them discussing the various laws that govern enforced disappearance and extrajudicial killings, mine will be looking at the aspect of Gen Z protest and the state-sanctioned disappearance. That when you look at what happened in 2024 in June, we had the controversial finance bill that happened, and our MPs voted for that bill to be passed. But the government ignored what the youth were telling them, that the high cost of living was too much. And the plight of Gen Zs fell on deaf ears. And we as youths, we resorted to going on Twitter and starting hashtag reject the finance bill. We started the slogan, Ruto must go. We started all that. But what did the state do? It resolved into aspect of state sanctions disappearance. And one of the most intriguing cases when you look at even Christmas, what the media was reporting, there was this young man called Billy Mwangi, that he was enforcedly disappeared by the police, and that when the father went to court and started crying to the court, "Where is my son?" The police, they did not. What was their response? We don't know where this young man is. So from all these cases of enforced disappearance, they are not isolated. It is systemic, and it happened and it will happen again. But what is the problem? That we have these laws, but impunity is the norm. That when you look at the politicians, that is when you look at even the president, what are our politicians saying? We will look into it. We are strengthening the laws. We will take this matter seriously. Even recently, he went and said that tutakomesha hii mambo ya abduction, meaning that it has been happening and they have not been doing anything to address this. They have not been doing anything to address it. And my personal reflection is that we talk about the legal framework, but it is harder to talk about the human cost. That From our research from Nakuru, we have sat across families which have been torn apart by these disappearance cases. And we have seen mothers hold on to hope, waiting for their children, who some of them will come and some of them will not come. And we have seen that brothers who are once full of life are now consumed by fear and silence. And me and us as the Gen Z, we feel angry that we live in a country where police can take people at will and nothing happens. And we also feel helpless that even with all the laws, justice seems to be sort of an illusion. And we feel afraid that because today it might be me, it might be Mbili, it might be the Kitengela brothers, it could be any of us. But more than anything, the more we continue speaking about these issues of enforced disappearance, is the more that our plight will be able to educate, that is the public out there. I now see the floor to Laureen.
Thank you very much, Laureen. Is Laureen able to address us?
Yes, I can.
Please.
Okay, good afternoon, everyone. My name is Laureen Atieno. I'm currently a project associate at Refugee Consortium of Kenya, formerly a Kenyatta University student. I also took part in the research, and I'll be focusing mostly on the response and reactions relating to enforced disappearance. You see, as highlighted during the Mandamano period, there was increased public awareness or interaction with the information around enforced disappearance, the people who are being disappeared, people campaigning for their release. And this is one of the tactics that the organization we're working with, in the Independent Medical Legal Unit, highlighted that with increased media presence, it's faster or it's easier to campaign or to push the government to release these people or do anything to investigate into the enforced disappearance cases. But with the cases we interacted with, you'd notice that there's always a time when there's a public uproar, and at some point the uproar dies and the family is left to handle the situation by themselves, to follow up on the cases by themselves, usually with the help of organizations, but there's a lot of despair around the same, And what we were able to find was there's usually three outcomes, let's say three major outcomes that tend to happen in such cases. Firstly, a victim may come back hurt or maybe released not hurt, as was seen in most Mandamano cases, but it wasn't the case previously. Usually, sometimes the victim is found dead, as we had one of the cases that trended in Kenya was the Kianjakoma case, where two brothers were killed during the curfew period, the COVID curfew period, and the victims were found dead, and those uproar on the same, and there's a case ongoing on the same, But in most cases, the victims are never found, and the family is left in despair. And the family, there's no direction towards the situation. They don't know whether to give up on the investigations or anything, or whether to just stop and move on with their lives. And I think this is the most torturous part, where they are left in a limbo, not knowing what to do. And you don't know whether the victim is out there needing help or not, or they might be dead. There's all that. And also in our many interactions, and also in line with my work, you get to find that there's multiple responses to this, because you'll talk to people about the same, and they'll want to justify the government's action, saying that is the government's response to the unruly youths, that is the government's response to gang violence. But does it really need justice in the end? So there's so much suffering that comes out of the same, and usually without the public uproar or without the campaigns around the same, the victims never seek justice. Actually, there are so many cases where they don't seek justice, and maybe that's why we are having such conferences, with the hope that more awareness can be raised on the same issue. Thank you.
Thank you very much, Laureen. Thank you very much to Professor Millie and from the good colleagues from Kenyatta University. We next move to Dr. Sarah Bireta, Director, Center for Constitutional Governance. Dr. Bireta will be generally addressing us on examining the impact of enforced disappearances on fundamental human rights in East Africa. Dr. Birete, are you with us?
Yes, I am.
Karibu.
Asante, I want to repeat the definitions by the previous speakers. I will go straight to the impact. It's important to note that there is increasing authoritarianism in the East African community, especially in Uganda, now unfortunately Kenya and Tanzania, and of course Rwanda, where these enforced disappearances and abductions are common. Most of the victims for these abductions are political activists, human rights defenders, political dissidents, like in the case of Rwanda, and then generally the minority groups. They are the most victims of these enforced disappearances, but also recently, like we saw in Kenya and has been explained, then the youth who participated in the Gen Z protests also became victims of these enforced disappearances and abductions. Previously in Uganda, I think Uganda could have been a pioneer of these abductions. From the time President Museveni was challenged by Dr. Kizza Besigye in 2001, the practice of abducting members of the political opposition started and has been growing in a systematic manner, to the extent that in 2021 elections, almost more than 100 supporters of Honorable Kyagulanyi, then the leading opposition candidates, were missing, and to date we have 18 unaccounted for, never seen for 4 years, supporters of Honorable Kyagulanyi. Similar cases of Tanzania, abductions in Tanzania have been reported, mainly by the opposition, Chadema party supporters and leaders, and the recent cases where prominent leader of Chadema went missing and only a dead body was discovered. In Kenya, we have the situation of protests that has been elaborated by the researchers working with the professor. And I will go straight to Rwanda, where dissidents of the Rwanda government have been abducted, including outside Uganda. Notorious among these is outside Rwanda, notorious areas outside Rwanda are abductions in Uganda, abductions in South Africa. They've dominated the abductions and killings of the political dissidents from Rwanda. Common among these abductions is the joint operations by the security agencies in the East African community. Connivance of security agencies to break the law, but also to undermine and completely disregard the extradition treaties and procedures that are prevalent in the East African community. We also have a case of connivance of the ruling regime in these countries. The leaders in these countries are copying from each other. Whatever happens in Uganda, if Uganda enacts draconian laws, close civic space, close NGOs, then you see the same happening in Tanzania after 2-3 days. The only savior in the region has been Kenya until the recent 2 years, where Kenya also competed with their fellow members of the East African community in undermining the fundamental rights and freedoms of the people, but also undermining rule of law, including sovereign law in the land or the constitutions of these countries. Taking an example of Uganda, the procedures of arrest are clearly stipulated in Article 23 of the Ugandan Constitution, but also a right to a fair trial is clearly stipulated under Article 28 of the Constitution, and the procedures of extradition that have been previously used, for example, the extradition of Jamil Mkulu, the head of the Allied Democratic Forces that have been fighting the government of Uganda for more than 20 years. The process took 6 months to extradite this rebel leader from Tanzania back to Uganda to face trial. And this trial was and is ongoing in the International Crimes Division of the High Court of Uganda. But to juxtapose this with the case of Besigye, then you have Dr. Besigye, who is abducted from Kenya, goes missing for 3 days, and reappears in a military court to having been found in possession of 2 pistols in Nairobi. This becomes a case in Uganda. What this demonstrates, in my view, is that we have total breakdown of rule of law. We have leaders that rule our countries or the region with total disregard of international, regional, and national laws, and basically the citizens are on their own. What impact does this practice bring about? We have total violation of fundamental rights and freedoms, especially the right to life and security, personal security. We have suppression of freedoms of expression and political association and participation. We have psychological and socioeconomic consequences out of these abductions, undermining the rule of law and judicial systems. And this practice has impact on regional stability and human rights advocacy across board. Enforced disappearances have devastating effects in the development of the East African nations, but also advancement of the EAC integration agenda through undermining civil liberties, rule of law, and inflicting long-term trauma on individuals and communities that are foreign victims. Enforced disappearances. Some minutes for the audience. Some of the possible solutions, Mr. Moderator, is judicial activism across the borders in the region, and citizens raising their voices to push back against the excesses of the leaders. Parliaments also upping their game in checks and balances on the impunity of the executives. And we need independent investigations on these forced disappearances and who is responsible for what, so that they are brought to book in regional, Africa, and international courts of law. We need also regional and international pressure on this vice so that we check the impunity before it gets out of hand. I thank you very much, Mr. Moderator.
Thank you, Dr. Biretta. Mheshimiwa Onesmo, please come and address us next and tell us what's the view from Tanzania.
Yes, good evening, everyone. On our part, I think you hear me, Evans Ogada?
Yes, I can hear you, sir.
Yes, I think we share the similar situation across the continent, and East Africa being one of the members of the African Union, as well as a member of the United Nations various human rights treaties. We have obligations to ensure security of our people, security of our countries and our borders. Now, this is an international obligation that our countries within the region have been so far given by various regional and international mechanisms. But the situation we are confronting within the region seems to be similar as what my colleagues have expressly stated. But my role, I just want to speak about mainly on how we are addressing these challenges, because my colleagues, the first presenter, has just highlighted on the key issues. But I want to look more on the challenges in addressing these challenges, problems, failures, and the gaps. It's good that we remind ourselves, first of all, about incidents of enforced disappearance, as it has been defined by our colleagues. These are the actions that, by whatever means, of course, there might, they always are supposed to be done in support or directly by the state agents or in support by the state agents. So, of course, perpetrators of enforced disappearance, kidnaps, and other sort of forced disappearance, most of the times states, according to our current context and what so far has been defined by the previous speakers, in most cases, states have been behind all this kind of enforced disappearance. But according to the conventions and the African declarations, of course, issues of enforced disappearance also touches other groups, such as military groups, those in conflicts, might be individual groups that are already organized and coordinated, but in support of states. So it's very clear, it's very good to understand from the very beginning, before we discuss challenges and gaps in addressing these challenges, who are the perpetrators and what are the mechanisms in place, and how are these mechanisms in place, are they effective to address these challenges? So the participants and all the people who are attending this sort of webinar, we should actually clearly understand the context of enforced disappearance we are speaking today, though it may appear in different forms. For instance, the number of enforced disappearance within the East Africa. As of Kenya, only last year, we were talking about 82 people. But looking at the statistic, Tanzania current statistic for the last 6 years, we have about 300 plus people, incident of enforced disappearance, and Uganda talking about 20-something around. Now, these are approved or recorded sort of incident, but we have a number of unrecorded incident of enforced disappearance. And in most cases, enforced disappearance that are those with elements that has been defined by the act, which is the deprivation of people's rights, and then at the same time there's concealment, that the state is not taking any initiative to address those concerns. Then automatically you understand whatever kind of incident we are talking about, state is involved. So the kind of enforced disappearance that states are not involved, for instance, child abductions or conflict between business groups and whatever, is not a subject of our discussion as of today. I think according to the definition that have been given, we are focusing on those incidents that involve abductions and enforced disappearance against human rights defenders, lawyers, critics, politicians, and how are these issues, of course, taken care by our governments. Now, the gaps and challenges. We have the international and regional frameworks that addresses these challenges. But unfortunately, most of our East African countries, almost all members of the East African community, have not ratified. Some of them have signed. For example, Tanzania signed, Kenya, DRC, Burundi have signed, Rwanda is silenced, neither side nor ratified. All the members of the East Africa have not so far ratified the convention, and all over the total of the East African countries that have ratified this, we only have 20 countries, and most of them are West African countries like Togo, Mali. They're the ones that have actually signed and ratified this convention. This tells you that we have a problem within the East Africa. So the major problem is the political will. There's no any political will to address incidents of enforced disappearance within the East African context. Even the report by the United Nations Committee on Enforced Disappearance indicates that there are no proper reporting of these incidents within the continent, and of course at the global level, just because, first of all, there's a high level of fear by the victims of these incidents. For example, if it is the police that have abducted you, or the state apparatus, security apparatus, there always has been sort of threats that when we release you back to the community, don't mention, don't do anything, don't report. So the number of incidents unreported just because of the nature of these incidents, that the perpetrators of these incidents which in most cases, as I said previously, state agents use threats for those who survive, for those who manage to escape from this sort of disappearance. When they come back, we have only few of them. For instance, in Tanzania, so many of them have managed to escape these sort of incidents, but few of them are able and have remained confident to speak about the entire, or what so far transpired during the kidnap or the entire process of enforced disappearance. So few of them, and this is also evidenced by the United Nations report on enforced disappearance, that failure to report is one of the challenges that we are confronting today, that so many people are abducted, but they don't report. So for whatever way, we cannot actually address these challenges if we don't have proper reporting. Now, another challenge that we are confronting within the region, we don't have national mechanisms. Of course, as I said, we have not ratified, and this international convention are not part of the law. Therefore, as what the previous speaker have explained, these incidents are not being criminalized. And if they have been criminalized, we are still following the normal criminal procedures, which are in whatever ways, we don't see that weight that has been provided by the United Nations or the international law. So this is another challenge. We don't have the legal, a very serious criminal justice system that addresses the problem of enforced disappearance within our national legal frameworks. Then another gaps or barrier that we are confronting, the judicial redress, the judicial mechanism within the East Africa, or at least Kenya recently tried to come up with a bold sort of a decision in relation to enforced disappearance. But on the case of Tanzania, like now Uganda, Burundi, all the rest of the East African countries. For example, in Tanzania, we went in one case, one of the young man who missed the last year, Soka and others, we went actually to court through the habeas corpus applications. And later on, the court just simply told us, no, that it is not the police. The police are not involved in this matter, but they have the duty to tell you their whereabouts. So that's all about the court in Tanzania that did. So we can see that other options, like legal redress, going to courts, are also missing. And these are the gaps and the challenges we are confronting. Out of this, we don't have cross-border sort of joint initiative. The East Africa community, we know this is one of the transnational crimes that requires cross-border interventions within our region. But let me ask yourself, do you have any mechanism that we have in the East Africa that requires our country, the cross-border initiative? We know what happened to Kizza in Nairobi, but it was simply done because we don't have that sort of cross-border initiative to address such kind of cross-border crimes and whatever, because this is part of the transnational crimes, cross-border crimes, but that require also cross-border sort of initiative to address such kind of challenge. So that's another gap and challenge that we're confronting within the region. But out of that, because as I said, this is something that is done by the states, but don't expect so far, it is very clear, don't expect the people who are committing such kind of offenses, that it is state apparatus, state securities, in most cases, who are accused of this, of committing such kind of crimes. Then do you really expect them to come up with a clear mechanism to address such kind of challenge? Maybe I leave this question to you. Do you really expect, in a situation where state apparatus are abducting, kidnapping people, to come and tell you that this is the mechanisms we want to use to address such kind of challenges? We should address that hard question. How can we address challenges such as this, where we have state apparatus, in most cases, some of the state agents or organized groups that are supported by state conduct such of it? How are we going to address? For me, I would really say community solidarity. We need to have civil society, we need to have lawyers, we need to have human rights defenders, we need to have other community groups, media. And the way the people of Kenya, you tried really very well previously, this is how we need to address these challenges, because there's no way out. Our people in power can sit down and develop a certain kind of a legal framework that addresses some of the crimes that are done within their cycles. I think this is very clear. And to me, if I may to advise my colleagues within the East Africa region, let's team up together as actors of human rights, defenders of human rights, civil societies, judicial activists, those some of us who are at least speaking about rule of law and human rights within the judiciary, media, university, lecturers, professors. This is the only way we can fight back such kind of incident within the region. We will actually have so many discuss on how to address the challenges. Even if we ratify this convention today, even if we develop national laws, yet we need to tell our people, our leaders, those in power, stop abducting us, stop kidnapping us. This is the only way we can find, we can actually put an end such kind of crimes within the region. Now, because still my time is with me, apart from addressing those challenges now, let's go back to reality, of course, within the region. That who are the most affected groups within the region? Of course, according to our own assessment that we've done for the case in Tanzania, we should also be very realistic at some point. Enforced disappearance or missing of people do not only involve those people like human rights defenders, the critics, the oppositions. It also sometimes involves children, for instance, a business community, those who are always in conflict among themselves. It also involves individual citizens with their own sort of conflicts. And so whatever kind of discussion we make, we should also be able to actually differentiate between those groups, because all the time, the defense by our government, they always say it is not the state that is responsible for all these sort of abductions and forced disappearance, giving out some of the cases that involve citizen and citizen. Yani watu wanatekana kwa kutekana. Now the state, because we have those kind of incident that mtu fulani na mfulani anamteka mwenzake, and now in most cases, the state will come with such kind of defense that it is not the state apparatus that are involved in such kind of incidents, by giving out such kind of few cases that it is, these are the cases that involve a citizen by citizens themselves abducting each other or whatever kind of offenses or crimes they are doing. These are normal crimes. That has been always their defense. So we should also know that and admit, yes, we know we have those kind of incidents. We have such kind of incidents where individual citizens force their colleagues to disappear. We have such kind of cases where, of course, because of business transactions or because of love affairs, such kind of incidents are there. But states are not involved in those areas. We are only talking about cases that involve politicians, human rights defenders, journalists, critics of the states, lawyers, and those who at all the times seems to be against those in power. Actually, this is what we have to be always address whenever we are coming into such kind of situation for discussions and whatever. We should admit that we have scenarios of that nature, but for the most cases that even the international community, the international law tries to address are those that involve state agents.
Thank you very, very, very much. That was Mr. Onesmo Ole Ngoromwa, a very powerful articulation of what really ails us in the region in terms of this phenomenon bedeviling the entire region, and that is abductions. Time is well spent. I don't know if, Gabriel, do we have Senior Counsel Charles Kanjama with us?
Yes, Mwalimu, Senior Counsel is on.
S.C. Kanjama, are you here with us, sir?
Yes, I'm present.
Good evening, good afternoon, sir, and welcome. We invite you to address us on your general thematic area, which is exploring legal and legislative approaches to strengthening accountability for enforced disappearance and extrajudicial killing. Welcome, Senior Counsel.
Thank you, Daktari. Is it possible for me to share a screen?
Yes, as
yeah, I think I can see.
You can, yes.
Yeah, possibility. Okay, so I hope you can see the screen that I have shared.
Yes, we can.
Yeah, so the topic I was asked to talk about, because this whole seminar is on abductions and forced disappearances and extrajudicial killings, is something that has already been addressed by several of my colleagues. My name is Charles Kanjama. I practice as an advocate of the High Court of Kenya. I'm also a senior counsel in Kenya, and I'm a partner in the firm of Moman Kanjama Advocates. I've been a member of the Rule of Law Committee of the East African Law Society in the previous period, the last 2 years. And the topic I was asked to address is regional, legal, and legislative approaches to strengthening accountability. So I'm just going to talk about things that we've already had touched on briefly, and I'll move as fast as I can, which is basically the legal approaches, the legislative approaches, and what are the institutions. So this topic is about human rights issue. All of these things, abductions, enforced disappearances, extrajudicial killings, are grave human rights concern. We've seen what has happened in the case of Dr. Kiza Besije, which is an interesting case because it involves cross-border violation of human rights in this area, where both Kenya and Uganda are implicated. And I think the question that I was asked to deal with is there a system of accountability against such acts? So first of all, just to set the framework, most East African countries are signatories to various international instruments, actually all the principal East African countries. And this includes the United Nations Convention Against Torture and the 1966 International Convention on Civil and Political Rights. And these international legal instruments, which are in the human rights field, oblige states to prevent torture, to investigate abuses, and to prosecute perpetrators. One of the big issues that has arisen in some of our member states, like Kenya, which I'm a part of that country, is that there are very robust protections in the law against these issues like abductions. And so lawyers go to court and they summon the police, they summon the infrastructure of investigations, and they make applications for habeas corpus, as we were hearing from one of our presenters from Tanzania. And the police come and say, no, we've not arrested so-and-so. When I was the chair of the Nairobi branch of the Law Society of Kenya, we had a particularly infamous case involving a certain lawyer called Willie Kimani. He was actually abducted by one of the branches of the police in Kenya, the administration police. They did not take him to a police station. He was not registered in a police station because they have an occurrence book where they record everyone who's formally been processed through the police system. In fact, the administration police in Kenya do not have ordinarily the right to maintain police cells. So they don't maintain their own cells. But they took this person to a container that they had in one of their camps. And after torturing him a bit, they took him from there to some wilderness. They tortured him further and they killed him. And of course, when you do an application for habeas corpus, the official position is no one has arrested this person. We don't know where they are. So these irregular gangs or groups that sometimes operate with the knowledge of senior people in the police in our various countries, they operate precisely on the sidelines, not within the law, but outside the law. So even if you have robust protections in your law, you find that these protections have ended up being ineffective. And so these instruments are talking not about just avoiding abduction, but also investigating abuses and prosecuting perpetrators, so that it should not be a commonplace for the police to just come and say, no, we don't know where this person is. Have you done any investigations? What is the product of your investigations? In the case that I'm telling you about of Willie Kimani, the Law Society of Kenya got involved in the habeas corpus application. And I remember we made an application to the court saying we want to get geolocation data from one of our major telco providers, our telecommunication companies. And when they told us they don't have that geolocation data, we actually went for a meeting. And I was in that meeting. They brought all the engineers. This was our big telecom company, Safaricom, and they spent some time trying to convince me that they don't have geolocation data. They are not able to give it to us. And even though we knew that they do have some of that data, we found it difficult to go beyond their plain statements that we don't have geolocation data. Unfortunately, in that particular case, the police got geolocation data, I think, through walkie-talkies, and were able to identify the principal culprit. So it's not enough to just have robust laws. We need a mechanism that can investigate and find those involved in this torture, arbitrary arrests, extrajudicial killings, and abductions. The East African countries have also signed the International Convention for the Protection of All Persons from Enforced Disappearance, but they have not yet ratified this particular treaty. And so one of our recommendations is that this is something we can push for the East African states. In the case of Kenya, there is constitutional protection, there's protection in the penal code against abduction, any threat to life. Enforced disappearance is, however, not defined as a distinct offense. And then we have a structure that involves the police, the oversight authority, EPOA, to do investigations when there are such suspicious things that have happened. But very importantly is that we have found it is the other players in this space, like Kenya National Commission for Human Rights and the Law Society of Kenya, which have played a principal role in fighting against abductions and extrajudicial killings. Because you can't do it just in the court. You need to do it in the public sphere. You have to raise the voice and put public pressure on those who are doing these things. In Kenya, we've had a very interesting situation where one of our cabinet secretaries, who was at the time the Attorney General of Kenya, publicly spoke about how his own son was abducted. And when he was very aggrieved about the issue, he went and spoke to the president. This is how he addressed the media. And then the president said, well, if the president made a phone call to somebody, I think it was the head of criminal investigation or the head of intelligence, and said, do you have the son of so-and-so? Can you release him? And the president told the AG, no, don't worry, he'll be released. And within half an hour, 1 hour, he was released. And this is in the public domain in Kenya. And of course, this particular abduction was not processed through official channels. So it's amazing how these things happen. And sometimes you have irregular forces that are participating in them that have been set up by the regular security services. In Kenya, there is a recent case from last year where the Law Society of Kenya went to court to get the Inspector General of Police to issue, to produce bodies of several people, living or dead, who had been abducted. And when, of course, the police failed to show up in the court, various warrants of arrest were issued. So it was a very dramatic situation. Uganda has similar constitutional protections to the ones in Kenya under the Constitution, the Prevention of Torture Act, Human Rights Enforcement Act. And they also have similar institutions like Kenya. The Uganda Human Rights Commission has been investigating human rights violation, and the Law Society has also been advocating against human rights violations. Recently, we've had the very curious case where even the president of the Uganda Law Society himself is being subjected to potential imprisonment for alleged contempt of court. But the case of Kiza Besije is one where the Uganda Law Society has tried to participate. You have non-government organizations like Foundation for Human Rights Initiative, Human Rights Watch, Amnesty International, that have been monitoring and documenting human rights violations. Tanzania also has constitutional protections. I decided to just focus on 3 of the East African countries as a sample. They have a penal code that criminalizes abduction. But of course, if the abduction is by state agents, it's difficult even to collect the evidence or to get people to issue witness statements and for the process to go on until completion. The Human Rights Defenders Coalition in Tanzania has a mandate also of empowering and supporting human rights defenders. And they have various other organizations, NGOs, the Tanganyika Law Society. So the situation in East Africa is very similar, at least for the 3 principal East African countries that I've referred to. I apologize for not doing a similar analysis for Rwanda, Burundi, and the other countries that have joined the East African community like South Sudan and DRC. The regional legal framework is mainly at the African level. You have the African Charter on Human and People's Rights, a protocol to the charter that establishes the African Court that is meant to introduce teeth or enforcement ability for violations of human rights. Some of these things are not easy to process in the country concerned because the state agencies are involved. And so there's an avenue of using the African Court on Human and People's Rights. And the protocol allows that court to deal with this kind of violations in any of the member states. And then we have the guidelines on protection of all persons from enforced disappearances in Africa. This is a document that was adopted by the African Commission on Human and People's Rights pursuant to the African Charter on Human and People's Rights. And it gives again states various obligations to eliminate enforced disappearances, abductions, and so on. So there's clearly need for us in East Africa to explore this continental mechanism as part of the way of dealing with violations and just failures to search, investigate, prosecute, and punish in our different member states, and also to try and secure redress for the victims. The failure by most East African countries to ratify the International Covenant for Protection of All Persons from Enforced Disappearance is one of the gaps. Also, our various institutions seem not to be very well equipped when there is a state complicity or complicity by state agents, because the state itself cannot really perform this job. It is state agents who are complicit in this enforced disappearance, abductions, and extrajudicial killings. My recommendations, and as I conclude, is apart from ratification of this treaty on enforced disappearance, is that we push for more robust legislation to explicitly criminalize abductions and enforced disappearances, and that where state agents are involved, to have more serious penalties and to have institutional protections. For example, IPOA in Kenya just has a few offices, regional offices. The amount of funds that they receive are not adequate for them to do their job of oversight of the police. So these oversight institutions over the police service in our different countries need to have more funds allocated to them. They need to be given more independence and to be made more robust. And then I think our human rights organizations, our NGOs, our law societies in these various countries have to take up this responsibility with greater robustness. At this point, I would like to really commend the Council of the Law Society of Kenya, and in particular the president, who's been at the forefront of the fight against abductions and disappearances of people in Kenya, especially connected to the Gen Z protests. So the independence of institutions has to be pursued. I think that is a critical issue. Allow me, as I conclude, to share one last document. It's just one page I want to share, because this is a document by the Kenya National Commission on Human Rights. The chair of the Kenya National Commission on Human Rights unfortunately passed on through sickness just a month ago. But they have been issuing several updates on enforced disappearances in Kenya. And you can see 4 weeks after the Gen Z protests in Kenya, which started on 18th of June, they give an update. They noted that there had been 50 people who had died from various issues. They spoke about abductions, arbitrary arrests, and torture. And they noted that 59 people had been abducted or were missing. And then they condemned this. They mentioned that the commission had moved to court seeking habeas corpus orders. They discussed about the police investigations that were going on. And they were basically saying that something needs to be done to stop what has happened. Unfortunately, when they gave their update in December, they were able to identify 7 people who had been abducted in December of last year. So you can see the abductions continued. 6 of those that they listed were still missing. And so the situation was continuing to deteriorate. It has become a tool, apparently, of irregular law enforcement, in quotes, by some of our state agencies against protest and anything they consider a threat to the stability of the state. So this is a call to human rights champions and to us as lawyers to be at the forefront of pushing for sobriety by the government, for government to have restraint, and to for those who are involved in these abductions to become accountable, because it is only when there is true accountability that future instances of abductions and forced disappearances and extrajudicial killings will minimize. Thank you, Daktari.
Thank you very much, Senior Counsel. Thank you for reminding us that we must not drop the ball. It's for us as those in service for human rights, those who are standing in the gap between citizens and tyranny, wherever we are. We must not drop the ball. And we at the East Africa Law Society, led of course by the president, Mr. Rama Abubakar, continue to make the call consistently that the rule of law and human rights must be adhered to throughout the region. We now go to our brief Q&A segment, and we'll be asking these questions randomly. I will go to Professor Mile. Professor Mile, are you with us? So briefly,
where should I be?
briefly, in 2 or so minutes, what could you say are the primary drivers or motivations behind abductions in East Africa generally? What are the primary drivers?
Thank you so much, Senior Counsel. I've been listening to the presentations. They're very enlightening. However, I realized something, that we have mostly spoken about high-profile cases, about people being abducted, and those people share the same educational background. They talk like us. They speak the same language. The research that we did in Nakuru, we did the research for the Independent Medical legal unit, which has been assisting the victims for years, also in low-income areas and in rural areas. And we have been interacting with the victims. When I say victims, I mean also the families who undergo through anxiety because of the fate of their loved ones that they are not aware of. Those people, I think the biggest crime they have committed is that they were poor. And I'm asking myself, you're asking, Evans, about the major driver. And I think we should also look at ourselves. I think the major driver is some perception that enforced disappearance and police violence is a legitimate method of security management. We give you another example. When there were claims that crime was on the surge in Nairobi, the city council went on to remove homeless people from footbridges. That was supposed to be a remedy to insecurity. Do we agree that the enforced disappearance and police violence, as soon as we agree with this, that it is a legitimate method of security management, enforced disappearances will happen? And it's the question that we must ask ourselves: security for whom? Security for the middle class, or also security for those who live in low-income areas and in rural areas, like the people we impacted? Some of them were not even aware about the legal avenues which the laws of Kenya keep open for them. And if they go to IPOA, actually, IPOA was scored quite well. Yeah? But as the senior counsel Kanjama said, IPOA is under-resourced. There's also some sort of distrust. Yeah? Many IPOA officers are former policemen. When I report to the police, who is investigating there? The DCI. So this is basically police investigating the police. And we found out that the local coordinator of IMLU, of civil society, was, I think, the most credible person there. He's been very active for years, also in the 90s, in the opposition. At that time, he was the person of confidence with people go. I think this is the key question. One, it was two key questions. Security for whom? Yeah. And do we agree that security management requires sacrifices on the part of most London? And if we do deep soul searching and we say no, answer those questions, then we will have a sound basis to address the issue of enforced disappearance. Thank you so much.
Thank you very much, Prof. As usual, allow me to recognize the presence of a former president of the East Africa Law Society, President James Agrimwamu. Welcome, sir. I wish to also recognize the presence of Dr. Daniel Ruweza, my good friend and teacher at Makerere University. Welcome, sir. Advocate Fulgence Masawe, a good comrade and patriot in Tanzania, doing a good job in terms of the civic space in Tanzania. My good friend and brother, partner at IKM, Mr. Hiram Nyaburi. Welcome, sir. We continue with our set of questions. I will want Dr. Birete to help us with this one. Dr. Birete Karibu, I need you to help us with this one. How have abductions impacted local communities, and what are the long-term social and economic consequences of these abductions? How have abductions impacted local communities, and what are the long-term social and economic consequences of these abductions? Over to you, Dr. Birete.
Thank you so much. Abductions, by their very nature, they disempower people. And when they are carried out, the outcome is devastating because these communities do not have the means to push back, seek legal redress, to find their missing persons. Abductions in local communities usually affect more than one victim. You find that, especially where land grabbing is involved, you find that families have gone missing, or many members of a given family, and the communities are traumatized. They live in fear. They cannot conduct any economic activities. And worst of all, they don't have the means. So the cost of seeking justice in most of the East African countries is so high, to the extent that access to justice, the recent report in Uganda on access to justice shows that only 10% of the citizens can access justice. The same or more, slightly higher, portion could be the case for Tanzania. Kenya, being the largest economy and with the biggest community of middle-class persons, has a slightly higher margin of citizens that can access justice. But if you go to vulnerable communities, you find that they cannot even report police out of fear. They don't have the means to move and search for their persons or file for habeas corpus or any other legal redress that could be available through judicial activism. They need legal aid. And when this legal aid is not present, because most of the deep rural families, again, have fewer people offering legal aid to vulnerable communities, the vulnerability increases. It almost, borders on the issue of extinction for these minority groups in our communities. They cannot carry out any socio-economic activity. Most of them move out of fear. They go into forced migrations to safeguard the remaining members of those communities. So these are the devastating impacts of abductions to vulnerable communities that cannot defend themselves. They cannot do any economic activity. They become stateless, they become landless, they become homeless, and they will most likely not recover from this state of affairs. Thank you.
Thank you, Dr. Birete. Dr. Birete paints a very gloomy picture of what devastation abductions meet in terms of communities in East Africa. My brother, my good friend, Mr. Olenguruame from Tanzania, are you here with us?
Yes, yes.
Sir, we have a question for you. How effective are regional collaborations, such as those through the African Union or the East African Community, in combating abduction-related crimes? Can we envisage cooperation within the East African region, the African Union, to combat instances of abduction? Over to you, sir.
Yeah, thank you. Talking about regional effectiveness of regional cooperation in combating such kind of incident within our countries, you may look at in two angles. First of all, speaking about those UN or African Union mechanisms, and then we also have non-UN or non-African UN mechanism. This we will speak about civil societies, other actors like lawyers, as what we are doing right now, like East Africa Law Society, the Pan-African Lawyers Union, who have also intercontinental, such kind of initiatives. So when we combine both together, we need to work together. But also, this one depends on how the UN-based, the African Union-based, or sub-regional, like EAC-based mechanism, how effective are they? This one depends on how effective are they, because at the end of the day, even if these other non-UN or non-regional actors are effective, if these other organs are not effective, then our work again remains as wasted of time and resources. For instance, the UN mechanism, the UN working group on enforced disappearance, they're doing a very good work. And even last, I think in 2023, we had them in Arusha. We had a lot of discussion on enforced disappearance. I actually read their report that was recently released, and they have had a lot of discussions at the UN level on the level and the state of enforced disappearance across the globe. And more than 600 cases were discussed at the UN level. So you can see that we have these mechanisms. They are also trying to do their work, but we don't see the larger impact of their interventions at national level. At the same time, we have the African Union, all the mechanisms, as it was by Senior Kanjama, the good mechanism that he presented, we have them. But we are not connected. We are not like working together in terms of coming together to address these issues. The UN mechanisms, the non-UN, non-UN mechanism at global level, the African Union and non-African Union at continental level, we are not coming together. We're not speaking together the same language. And this is I came to realize that it seems the mechanism, the way they work, is only an issue of developing mechanisms. They come out with conventions, they come out with the regulations as what we did in Africa, guidelines, and then just end of it. There's no any clear mechanism where they can make, you look at the way even the ratification status, and the way these mechanisms, especially the non-legal mechanisms like special groups within Africa, they are not addressing issues as they appear. They don't speak those issues. For Tanzania, for the last 3 years, we've been speaking about enforced disappearance. We've written them email, inviting them to come, and then they don't appear. The same to other countries in Kenya and whatever, until they just wait their time to develop reports and other things. So my proposal is that civil societies, because that's where we have hope, civil society, human rights defenders, lawyers within the region, let's cooperate. Let's find a better way for us to come together and address these problems as common problems. And it's a good thing that the international legal framework has defined it as crimes against humanity. So it's something that we need to take from there, because at least the legal frameworks at international level, regional, has made us a good work of clearly stipulating what is it about. But now it's our role to come together. And whenever there's a situation, for example, what happened to Kizza Besigye in Nairobi, then an incident like that could have provided us an opportunity to come us together and address issues collectively within the region, and not leaving that work to, of course, I know some of the lawyers from Kenya tried to go and join their colleagues in Uganda to address the situation of Kizza Besigye. But this kind of intervention, we need to see them increasingly coming, and should have such kind of cross-border joint interventions whenever we have an HRD or a situation of abduction in South Sudan or in DRC. We need to team up, and using our regional organs. Of course, we have national entities, groups, but we also have sub-regional like East Africa Law Society, PALO, and others, and other human rights defenders network within the region. We need to have this a clear mechanisms and guideline on how are we going actually to collectively address incidents such as this, as we have actually agreed here, that these are state-led kind of incident and crimes. So it's not easy to tell them that come up with a law and then you end there. Come up with a certain mechanism like what you have in Kenya. Kenya, you have a police oversight body, but that one cannot help. No. If at all we don't have extra forces to make them do their work effectively. Suppose it's a police or other top officials within the police are the ones involved. Do you think that independent oversight body can do something? Actually, we need other actors like civil society, human rights defenders, and outside the country, outside the continent, creating a certain sort of a synergy so that we can work together in terms of addressing issues that, as they appear. So for my conclusion on this is that we have this framework, UN and UN, African Union and African Union, civil society, human rights defenders, lawyers. Of course, we've been speaking, we're addressing, but we are not speaking together. We are not coordinated in a manner that we make tangible impact. These things are happening, actually affecting our people within the region, creating fear within the region. The victims are not compensated. We don't see any sort of, legal measures taken, but we are not taking certain kind of coordinated initiative and measures to end such kind of incident within our region.
Asante sana ndugu Onesmo Olengurumwa, asante sana kwa mchango wako madhubuti. Thank you very much, Mr. Onesmo Olengurumwa, for your great and meaningful contributions. Finally, to you, Senior Counsel Kanjama, are we together with the SC here?
Yes, I'm with you.
So the question is this to you, SC. What role do technology and data play in tracking, preventing, and responding to abduction incidents in East Africa? Or rather, what role ought or should technology and data play in tracking, preventing, and responding to abduction cases? Over to you, sir.
The first thing I will say is that technology is being used as a tool to assist the process of abductions. And we are aware that in Kenya, for example, those who are involved in abductions, when they are connected to state agents, they have a way of tracking their targets using a telephone, a conversation, or geolocation. They have a way of tracking where you are. And some of those who are abducted and later released explained that the way they caught them was by making calls to them, finding out where they are, not because the recipient said, I'm at such and such a place, but they used technology, some of them, to facilitate locating the potential suspects. And then that means technology can actually be deployed to help those who are fighting against these irregular practices. First of all, our telco companies have to be put on the spot because some of them have given access to their networks, to the intelligence agencies, which are used occasionally for, I don't know, counter-terrorism or other intelligence gathering work. And then when it comes to helping to fight against abductions, they seem to go mute. And so they need to facilitate those who are human rights defenders to have a mechanism, whether it is through the communication authority of the different countries, to get access to this kind of data. In the West, we found that because there is a prevalence of video evidence, many people have CCTV cameras, dashboard cameras in their vehicles. They are taking many videos using their mobile phones and so on. Many incidents of crime are recorded using technological devices, and this becomes very useful evidence when you try to unravel these situations. And so that means that even in East Africa, we need to see how we can utilize more of this technology and tools to capture photographic data, video data, and evidence, location data, and so on. So there's definitely a lot of potential for the use of technology in helping to deal with abductions and extrajudicial killings. I had mentioned in my previous presentation that I was at the forefront in one particular case of abduction that converted to extrajudicial killing, in making an application to the court, to the High Court for orders against a telco provider, and then going for a meeting with the telco to explore what kind of data they could give us. And I think we should also demand to find out what kind of data these telco companies actually collect regarding their subscribers. Maybe we should even do some applications in court to find out what kind of access. This is also related to issues of privacy that they give to state agencies that then sometimes can be misused to facilitate things like abductions and that later become extrajudicial killings. So in conclusion, Daktari, I think there's a lot of potential for use of technology and the various technology devices and resources to help us in this fight against extrajudicial killings. And we may need to also call upon our friends in other countries, including neighboring countries that are more advanced in how to use technology to help identify cases of abductions and confront them. Thank you.
Thank you very much. From Senior Counsel, technology can be both a blessing and a vice. Technology has been used to aid abductions. Technology can be used to solve abduction crimes, can be used to help in stymieing this scourge of abductions. Thank you very much, Senior Counsel. We now go to several questions that are within the chat box, and I will request humbly and respectfully that those with questions, please keep them short and precise. Keep them very short and precise. I saw a question from Kana Duba. Kana, do you want to raise your question? Keep it very short, Kana. Is Kana with us? I saw another question from Fulgence. Fulgence, are you here? Fulgence? ICT? Do we have technological challenges? Rukundo Charles, is Rukundo here with us? Any question from anyone? Raise your hand so that we can see you. I see Jadida Anyango. Jadida, please, your question.
Yes, am I? Oh,
Yes, you are audible.
am I audible?
Yes, you are.
Yes. Thank you very much. This it's been a very beautiful discussion. I have a question. The government has been creating committees towards looking into or investigating issues of abductions and enforced disappearances. I am aware that there are committees instituted within government bodies with effect to the same. However, once these committees are instituted, we do not see much of the outcome from what these committees do. So what can be done to compel or to enforce the recommendations or reports or suggestions that come out of these committees? Thank you.
So the phenomenon of reports gathering dust. Jadida, who do you want to ask the question?
I'll pose it to anyone who will answer.
Anyone who answers it. Senate Kanjama has worked in such commissions, such reports. SC Kanjama will want you to attempt that for us. Did I see Mr. Olengorumwa raise his hand?
Actually, I wanted just to give two examples of what Senior Kanjama presented on first one, an example of how the way technology has been aided, has been used to for those incidents like abductions and extrajudicial killing. We have an incident that involved the Tundu Lissu, Honorable Tundu Lissu in Tanzania. I think we have heard that case about the Tigo company, the telecommunication company in Tanzania, commonly previously called the Tigo. The way actually that matter was taken even to UK and revealed that there were a lot of communication between the killers and the telecommunication company in terms of linking informations and whereabouts of the victim. And then secondly, on the positive side, recently we had one attempt of enforced disappearance that the usage of CCTV camera actually were later on used to indicate how that person was about to be abducted. So I wanted just to give those two examples showing how a digital world today, or the technology can be used both to aid abductions, or sometimes to provide details and informations about abduction on the positive side of the victims. Thank you.
Thank you. Thank you very much, Mr. Onesmo. We have Lugard Kokulinda. Lugard. Is Lugard with us?
Yes, I'm there.
Yes.
Thank you very much for this opportunity. My concern is we have mechanisms in place. For example, we have the East African Court, we have the African Court, and we've seen incidences where cases have been filed there of abductions and other abuses, and positive rulings have been given, but governments and their agencies either don't respond, or maybe they refuse to abide by the rulings. And I'm just wondering what more, what's that can be done? I mean, we can have collaboration, we can have coalitions, but these governments are adamant. Just tell me what we can do to force them to abide by the rulings.
So, Lugard, who do you want to answer your question?
Anybody.
Anybody? I'll want that question answered by Professor Mile. Professor Mile, we'll want you to answer that question. Did I see Fulgence Masawe with his hand up?
Yes, for sure.
First. Yes, Fulgence. Welcome, my brother.
Okay, let me ask you, Thomas, first, the first question. The issue of impunity, Thomas, how do we address this issue of impunity? We have the cases where there are these incidents of abduction, forced disappearance, and so forth. And in some instances, we came later to find out that there is involvement of government apparatus or government institution by one or another. Let me give some few examples, like what happened in Kenya recently, the issue of Issa Besigye. I think that was a pure abduction, because you can't say that was extradition or something like that. How do we hold these governments accountable? And for the case of Tanzania, Olengurumwa, you are here, with the cases of Ali Kibao, with the case of Kombo in Tanga, and then we have to know how to hold these government institutions accountable, because I can see the issue of impunities all over. But we have also the role of the special rapporteur, both at the African Commission, UN mechanism, and so forth. Where are these people who are responsible as special rapporteur? Because I saw that cartoon other day from the Kenyan cartoonist, originally from Tanzania. He called the East Africa the Afghan, is it abductionist, like Afghanistan? I don't know how to mention that. Or Ghana, you can get. He called it optional. What was it, Thomas? I think you saw it. How do we? Because the East African is being branded like Afghanistan, but they are abductionist states. Because what is happening in Kenya is happening in Uganda, what's happening in Uganda, it's happening in Tanzania, it's all over. How can we hold this government accountable? Because there is the issue of impunity. There are cases which are very clear that. And how can you address it at the UN or any international mechanism? Thank you. It's for you, Thomas.
Thank you. Thank you very much. Let's deal with those questions first. I see one more hand up. We start with Senior Counsel Kanjama, then we go to you, Professor Mile. Professor Kanjama, there's this question from Jedida. We write reports, we make recommendations, they gather dust. So what? What can be done to compel the enforcement of these reports? Over to you, SC.
Thanks, Daktari. The reports will continue accumulating, and it's good to have reports. But we need to have somebody, maybe the Law Society itself, start a practice of compiling these reports, reviewing the reports, and determining who should be involved in enforcement. Because this is what is called advocacy. Advocacy means, I remember seeing a slide talking about advocacy. And it says advocacy means say what you mean. Say what you mean again, say what you mean again and again and again. So if you just say it once, you're not doing advocacy. People forget. You have to use the psychology of advertising. You have to keep repeating in different ways to different people, to the same people. And that's what we've tended not to do. We get satisfied once we've produced a report, maybe you've hosted a press conference, you've circulated some copies, then you move to the next agenda. Even ourselves as the East African Law Society Rule of Law Committee, for example, we published the second edition of the Rule of Law report last year in November. So the question is, are we now satisfied? We've given a tick, we've sent it to a few libraries and organizations, and now we are waiting for the third edition. So that issue of getting the impact is half of the job that needs to be done. In litigation, we say that getting a judgment or a decree is half of the job. The other half is enforcement. And sometimes the lawyer gets a decree and they tell the client, here's your decree. But a decree, if it's not enforced, is a worthless piece of paper. So I would like to say that the reports, they are useful in the sense that they give us information, but we now need to have maybe even a structure, a committee or something that is focused on enforcement of some of these reports. You have to digest them, make them simple for the common mwananchi, maybe produce some infographics, some simple summaries of these reports, and then identify a few, not too many, but a few focus areas for enforcement. You might have a report of 50 pages, and you just need to enforce 2 ideas or 2 resolutions from that report, and that would be a success. So that has been something that has been lacking, even within the law society, within the civil society space. And there is a gap that maybe some of us can take advantage of it, including your committee, Daktari, since you chair the Rule of Law Committee, maybe that can become one of the issues we focus on. Thank you.
Thank you very much. Enforcement. The reports are there, beautifully crafted, but without enforcement, that it remains a gap. Thank you very much, SC Kanjama. Professor Thomas Mile, 2 questions were directed at you. My good friend Fulgence directed 1 question at you. There's also the question by Lugard Kokolinda. Over to you, Professor, with the 2 questions.
Thank you. Thank you so much. So the questions and now your interventions, dear Councillor Gada, made me think that we are perhaps falling into a trap, because we keep repeating that we have excellent legal framework which is not implemented, that we have mechanisms in place which are not working. But perhaps our legal framework is not as excellent as it should be. Perhaps our mechanisms are not as efficiently designed as it should be, or just simply under-resourced. Give you one example, the reluctance to ratify the International Convention for the Protection of Persons from Enforced Disappearance. And I think it is not it is not ratified for a reason. And the reason might be that this convention provides for criminalization of enforced disappearance. So if you ratify, enforced disappearance should be a crime. Provides for a duty to investigate, actually duty to search for people. The African Commission guidelines clearly say that people, if reported, should be searched, should actually look for where the people are who are missing. From our experience in Nakuru, nobody reported as disappeared has ever been found alive. So this is where we are. Now, we are talking about IPOA in Kenya. IPOA is a great achievement, and most other countries do not even have IPOA. But let us look at IPOA. Let us look at the powers IPOA has. And let us also look at composition of IPOA. I alluded to that earlier. Many officers are city police officers, retired police officers. How do we guarantee that, I quote James Madison, ambition is created to counteract ambition, so that we have an institution which has an ambition to investigate abuses of power by the police? Many officers in IPOA have such an ambition, but there are also those who do. And even if they do, the public does not trust this institution as much as we would wish to. Number one, so perhaps we should really look at the efficiency of the legal framework. Number two, even if we create institutions, do we provide those institutions with adequate resources? So the quite common complaint is that IPOA is under-resourced, that there are not many, if we had it even today, a number of regional offices, not enough officers, and also witness protection agency. Yes, we do have a witness protection agency, but because of the lack of resources, the witness protection agency is not in a position to protect witnesses. And if it is not in a position, people will be afraid of reporting cases of enforced disappearance. So it is up to the legislator, actually, to make sure that the legal framework is sound and that the institutions that we create are adequately equipped. It is for the legislator to do that. And why does the legislator does not perform this task as efficiently as we would wish? We should look into the quality of our democracy. I'm sorry, but there's no way that we would have an efficient system of protection against enforced disappearance if we don't take care of the quality of our democracies. And it is not all that bad, by the way, because the Kenyan Senate in 2021, actually, the Legal Rules and Privileges Committee had a hearing on that. What about enforced disappearances? And the committee in October 2021 advised in the report that Kenya should ratify the convention and criminalize enforced disappearances. And even the Attorney General was to report back to the Senate within 2 months what has been done. That was in 2021. In 2023, the same. The Attorney General made a promise that Kenya would ratify. That was 2 years ago. We have still not ratified. We must strengthen the accountability mechanism, and this is only through the quality of democracy. Now, my final remark, there was something about regional bodies in African Union, East African Community. Yes, they can help, but they can help only in a small percentage of cases. Enforced disappearances are widespread. So we cannot have one East African Court of Justice. Hoping for one East African Court of Justice assisting us. However, as I said, in the Placeda Rugunda case, the mere fact that a case was filed, actually made it possible that the Rwandan authorities revealed the whereabouts of the missing person. And this is quite important, raising voices. Yeah? Because the main problem with enforced disappearance is that people are placed outside of the protection of the law. And if you put enough pressure, generate enough pressure, yeah, to civil society, but also through politicians, through MPs, yeah, those persons must still be incarcerated, yeah, but they will be brought back under the protection of the law. My final remark, East African Legislative Assembly. I think much underestimated when it comes to its potential, and it is there. Yeah, East African Legislative Assembly was actually in 2016. Yeah, quite efficient in investigating or reporting of human rights violations in Burundi. Yeah, the committees may discuss all the matters, they may pass a resolution, and they may generate pressure. Yeah, pressure to release people and pressure, for example, to ratify the convention. The good thing about the East African Legislative Assembly is that we have also MPs from other partner states that are not as embedded in the local political networks, I would say so. Yeah, so perhaps they can say more than the local politicians can. Thank you very much.
Thank you very much. Thank you very much. And if you watch Professor Mile's background, he has an article behind him there upholding judicial independence in Kenya. He is a truly in the institutions person. He does a lot in terms of looking at institutions in Kenya and in East Africa. That's the publication I'm talking about. Please share with us the link where people can read that publication of yours. Thank you very much, Professor Mile, as usual. We have this person identifying himself or herself as iPhone. Please ask this question. Dr. Birete, please help us answer this question in about 2 minutes. Over to you, Dr. Birete. iPhone, ask your question. Dr. Birete responds. Is he here? Okay, Dr. Birete, the question is this. In cases where governments in East Africa refuse to enforce rulings from the East African Court of Justice, what are some of the options that can be explored? Over to you, Dr. Birete.
Well, thank you very much. Uganda has been notorious on ignoring East African Court of Justice decisions. Uganda is also notorious in ignoring our own Supreme Court decisions in Uganda. Cases the trial of civilians in military courts, where the government has moved to gag its ruling party caucus to reenact the immediately repealed sections of the UPDF Act to again start trying civilians in military courts. What message does this send to the people? That we have total breakdown of rule of law, we have total disregard of court decisions, and the executive, I'm using Uganda as an example to answer the question, because I think we have more impunity in the country as compared to the other East African member states. So in Uganda, we have the executive that is above the constitution, above any legal instrument, regional, international, national, otherwise. So what we need to do as East African citizens is to attach a high political cost to this impunity by mobilizing citizens to push back. There is no other way out of a situation that our countries are getting into than having citizens at the front line, back citizens with judicial activism, attach make it too costly politically for any leader to exercise impunity and authoritarianism in our countries. Thank you.
Thank you very much. Make it politically costly. Ladies and gentlemen, it's 4 o'clock. We have spent our time well. I want to thank our panelists. And before we end today's webinar, I'll want concluding remarks from each and every of our panelists. Concluding remarks, let's do it in about a minute each, and then we come to a close. Thank you very much. I will start with Mr. Olengurumwa. 1 minute for you, closing remarks.
Thank you, Mr. Ogada, and all the presenters and participants. My message to you, as far as abductions are done or supported or sponsored by state, with all the efforts we are putting to have laws, ratifications, reforms, please, as citizens, we have that role of ensuring that all incidents of enforced disappearance, extrajudicial killings are stopped within our country. We have that duty as citizens. That's the only duty that it's only we, citizens of these countries, who can stop that. I think this is my message to you.
Thank you very much. Professor Mile, 1 minute closing remarks.
Thank you very much. My plea is, I'm pleading with you that we agree that enforced disappearance and police violence are not legitimate methods of crime prevention and security management. Never. That's number one. Number two, I just would like to agree with Dr. Birete. The quality of the democracy is crucial. Political accountability, civil society engagement, it's a hard work. There is no shortcut. Thank you.
Thank you, Professor Mile. Dr. Birete, final remarks?
Well, I largely agree with the panelists with their concluding remarks. And just to re-echo what I've just said, that it will take citizens at the front line through civil disobedience, through protests, to increase the political cost of impunity in our countries. But also lawyers will play a critical role. Judicial activism, protection of citizens as they take the front line to push back against dictatorship, authoritarianism in our country, but we also need to loop in the international pressure. We live in a global world. We should make sure that our protests, our civil disobedience is at all international fora, UN platforms, to embarrass our dictators by publicizing the acts that they do and how they treat their citizens. I thank you very much.
Thank you, Dr. Birete. Senior Counsel Charles Kanjama, take us home.
Okay, thank you. So I'd like to, first of all, appreciate the Rule of Law Committee of the East African Law Society and our chair, Dr. Evans Ogada, for this fantastic webinar. We are in a situation of crisis in our various countries in East Africa, with many people tolerating these vices, which are serious human rights violations of abductions that become extrajudicial killings and also enforced disappearances. And I think it's time for human rights champions to come together to fight this vice, to coordinate, to network, to reflect on what are the mechanisms that we can use to be more effective in this fight against this vice. And even in our member states where there's some kind of like casual approach or attitude to some of these things like abductions, even cross-border abductions, I think there are many people who are not happy with what is happening, because today you will be observing an abduction of someone else, and tomorrow it will be somebody from your own family. We've seen that even a member of the cabinet in Kenya is not insulated from this kind of like marauding people or groups or gangs that are involved in these vices. So we need to also forge partnerships with well-meaning people in government agencies, including the independent ones like the Human Rights Commissions and the police oversight agencies, so that we can fight this vice. And then I think one of the things that can help us to become aware of how deep the vice is precisely in answer to one of the questions that was asked, to make a resolution to start compiling the reports and the data that is out there produced by various organizations on the statistics regarding these issues of extrajudicial killings, abductions, and enforced disappearances. Because it is when we blow the whistle to the extent of the vice, of the human rights violations, that we can start creatively and aggressively working towards solutions that are effective. So that is my prayer to the East African Law Society Rule of Law Committee and to everyone else participating in this meeting. Thank you.
Thank you very much, Senior Counsel, and thank you very much to all the panelists. Mr. Wekesa, we have noted your question. What I can tell you is this, you had asked a question about what is the East African Law Society doing about mobilizing members to allow cross-border representation in terms of helping with abduction cases. I can tell you that the Rule of Law Committee, together with the Council of the East Africa Law Society, are doing a lot behind the scenes in partnership with national bar associations. Recently, you saw the solidarity that was extended to Senior Counsel Martha Karua from Kenya to go and represent Comrade Kiza Besije in Uganda. Kiza Besije was afforded considerable help with some aspects of his case here in Kenya. So there's that local partnership and solidarity that happens across region in whatever country violations happen, and that is usually coordinated by the East Africa Law Society. Ladies and gentlemen, thank you very much. For those of us who are French speakers, merci d'avoir assisté à notre webinaire d'aujourd'hui sur les enlèvements. Nous avons hâte de vous retrouver lors du prochain webinaire de cette série continuée. We thank you all for attending our webinar today on abductions. We look forward to having you on the next webinar in the continuing series by the East Africa Law Society as we soldier on with our quest to make the region a more humane region that respects human rights and the rule of law. That having been said, thank you very much to all the attendees. Thank you for taking your time and being with us here today. We look forward to having you in the next webinar. Over to you, Mr. Gabriel Achai, if you're here with us.
All right. Thank you so much, Mwalimu Evans Ogada, for your very insightful and very active classroom this afternoon. On behalf of the society, I would like to extend a sincere appreciation to you, Professor Thomas Millet, Senior Counsel Charles Kanjama, Dr. Sarah Birete, and Mr. Onesmo Orengurume, who has unfortunately already jumped out of the call. And to you, our esteemed participants from across the region, for joining us this afternoon. Indeed, you have not let the heat wave prevent you from being part of this wonderful discussion. And at this juncture, I would like to say that officially our webinar has come to a close. We'll be sharing a recorded version of this on your different email addresses, and we will also issue out certificates of attendance for you, our participants, and a certificate of appreciation to you, our esteemed panelists, for your contribution to this discussion. So our series continues. On Thursday, we'll be having a discussion that is hosted by, in partnership with CIAP, the Kenyan branch, and we'll be discussing mastering dispute resolution in East Africa's key growth sectors, and we'll be discussing practical practical notes from different experts from across the region. And then on Friday, rather on Thursday, we'll be having another session that is hosted in partnership with Anderson East Africa, and we'll be discussing navigating the new wave of private wealth, and we'll be discussing the legal trends that are shaping the future of high net worth individuals and family offices. And if you'd like to be part of these sessions, please register for the same, and we look forward to seeing you on Thursday and Friday. And for now, we're signing out and wishing you a very lovely afternoon, and stay blessed and safe until we meet again. Goodbye.